Two legal findings. Same judge, opposite conclusions. In April 2024, a coroner ruled that SAS soldiers were justified in shooting 3 IRA men at Coagh, County Tyrone, including an unarmed driver. In February 2025, an inquest ruled that lethal force against 4 IRA men at Clonoe, 11 miles away, wasn't justified, not reasonable. The soldiers, the coroner found, didn't have an honest belief that shooting was necessary. The same judge, Mr. Justice Michael Humphreys, Northern Ireland's presiding coroner, delivered both decisions. That pairing looks like a contradiction. It isn't. The two findings describe the results of 2 different proceedings, examining 2 different operations on 2 different bodies of evidence. The law didn't flip. The facts did. Coagh first. 3rd June 1991, shortly before 7:30 in the morning. A stolen Vauxhall Cavalier crosses from Moneymore, County Londonderry, into the village of Coagh, County Tyrone. Inside are 3 men from the IRA's East Tyrone Brigade: Lawrence McNally, 39, Michael Ryan, 35, and the driver, Tony Doris, 21. The car slows as it approaches a small public car park off the main street, beside the Hanover House Hotel and a block of public toilets. The unit is on its way to kill a man. Intelligence gathered the previous month warned RUC Special Branch that the East Tyrone IRA planned to assassinate a former part-time member of the Ulster Defence Regiment, a kitchen factory worker named Alistair Harkness, who parked in that car park every morning at 7:30. The IRA had already murdered Derek Ferguson in Coagh on the 9th of April 1991, claiming he was a UVF man. His family denied it. The tit-for-tat cycle around the village had been running for years, each killing feeding the next. The security forces knew the attack was coming. They considered flooding the area with uniformed patrols and rejected the idea. That would only delay the assassination, not stop it. Instead, they planned what the inquest record would later describe as a hard arrest operation. A decoy was placed in the car park, an SAS soldier who had dyed his hair and padded his upper body to mimic Harkness, sitting on a low wall reading a newspaper beside the maestro. A cover group waited inside a modified flatbed lorry parked across the road. An observation post watched from the first floor of the hotel. The decoy was armed with a Browning high-power pistol. The inquest record identifies the soldiers only as members of a specialist military unit of the British Army. Open source accounts name them as the Special Air Service. Either way, the planning was detailed, and the soldiers' accounts of what happened next would eventually face forensic scrutiny that took 3 decades to arrive. The Cavalier stops at the entrance to the car park. The rear passenger door opens. A man wearing a balaclava rolled up to his head, the inquest identifies him as Lawrence McNally, steps out carrying a Romanian AKM rifle. He shoulders it and points it directly at the decoy soldier. The decoy jumps the back wall. The SAS officer in command, recorded as Soldier H, gives the order. The sides of the lorry drop. McNally falls back into the car. Doris tries to drive away, but he is hit immediately. The Cavalier careens up the street and crashes into parked cars. The arrest group arrives and joins the shooting. The engagement continues until the car explodes in flames, setting a parked Volkswagen Golf alight. When the fire burns out, the bodies of McNally and Michael Ryan lie on the road beside the passenger side. Tony Doris is slumped across the front seat. They are so badly burned that identification requires dental records. The scene yielded 2 Romanian AKM rifles, a bulletproof vest, and spare magazines. At the time of the Coagh ambush, both AKMs were set to fully automatic, loaded, with a total of 136 unfired rounds in their magazines. How many rounds did the soldiers fire? Reporting at the time and in legal proceedings put the figure at up to 150. The coroner would later conclude, on the balance of probabilities, that no IRA member discharged a weapon at all during the incident. There was a video. An SAS soldier, recorded as Soldier U, had filmed the entire incident from an unmarked surveillance van parked at the crossroads of Coagh Main Street and Hanover Square. The recording showed the car's arrival and the engagement. It also showed the faces of the SAS men. The soldiers decided it compromised their identities and destroyed it. Asked about that decision years later, Mr. Justice Humphreys said there could scarcely have been more probative and significant evidence of the events at Coagh. If it had survived, it would have rendered the task of the inquest on many of the issues straightforward. Its destruction, he concluded, demonstrated a clear and unequivocal willingness to subvert the rule of law. He had other criticisms. The original RUC investigation into the shootings, he said, was woefully inadequate. The decision not to prosecute the soldiers, reached in 1992, was made on the basis of untested and unchallenged accounts of soldiers. Evidence at the scene was wantonly disregarded. No questions were asked of the men who planned the operation. Those words matter because they complicate the easy version of this story. The Coagh inquest didn't clear the state wholesale. It found the soldiers' force lawful while simultaneously finding the planning defective and the follow-up investigation negligent. Both conclusions sat in the same judgment. The inquest into the Coagh deaths opened in 2022. On the 11th of April 2024, Mr. Justice Humphreys delivered his findings. He concluded the three men were members of the East Tyrone Brigade on active service. Then came the operative holding. In each case, the use of lethal force was justified as the soldiers had an honest belief that it was necessary in order to prevent loss of life. The use of force by the soldiers was, in the circumstances they believed them to be, reasonable. He was satisfied the force was reasonable and proportionate. And yet, in the same judgment, the operation wasn't planned and controlled in such a way as to minimize to the greatest extent possible the need for recourse to lethal force. Justified force, flawed planning. Both findings won judgment. The legal challenge came from Tony Doris's family. A relative, Roisin Nugent, mounted a judicial review. The precise relationship is recorded differently across sources: sister in some reports, daughter in the official summary. Her lawyers argued the coroner should have distinguished between Doris, the unarmed driver, and his armed passengers when assessing lethal force under Article 2 of the European Convention on Human Rights. Their argument: Doris was unarmed, he was trying to drive away, and the threat he posed was distinguishable from men carrying rifles. The High Court refused permission to apply for judicial review in October 2025. Mr. Justice Michael described the challenge as unmeritorious and utterly divorced from the reality of the circumstances. He added that had he determined the matter on its merits, he would have unreservedly upheld the coroner's findings. The case reached the Court of Appeal on the 16th of April 2026. Lady Chief Justice Dame Siobhan Keegan, sitting with Lord Justice Colton and Mr. Justice Fowler, dismissed the appeal. The court found no arguable legal error had emerged and that the challenge really amounted to a disagreement with the coroner's findings. The key passage of the ruling concerned the unarmed driver. Soldier B had fired 8 rounds in 1 or 2 seconds, killing Doris. Dame Keegan held he had responded proportionately in a lethal situation. Her words, "Mr. Doris was part of the threat to life in this fast-moving situation." It would be absurd to disaggregate the driver from the other men in this case, all active members of the Provisional IRA, part of a plan to murder which clearly involved an imminent threat to life, which Soldier B sought to protect. The court held that the coroner was entitled to view the occupants of the car in the way that he did as a group of terrorists who posed a collective threat. The news report summarized it as, "An SAS soldier was justified in shooting an unarmed IRA driver." That is roughly accurate, but it is important to be precise about what the Court of Appeal didn't do. It didn't conduct a fresh factual inquiry. It didn't take new evidence. It didn't decide criminal guilt or innocence. There was no conviction being appealed. It asked a narrow question. Had the coroner applied the correct legal test and reached a rational decision? The answer was yes. The court's ruling was about the lawfulness of the coroner's reasoning, not a retrial of the ambush. One more detail from that period. A former SAS soldier, recorded as Soldier F, a different man from the Soldier F of the Bloody Sunday proceedings, had been involved in planning the Coagh operation. He refused to give evidence to the inquest. In early 2024, Lady Carmichael in the Scottish Court of Session sentenced him to 6 months' imprisonment for contempt. On 24th of April 2024, the sentence was quashed on appeal and replaced with a fine. Inquests into state killings rely on soldiers' testimony. Not every soldier was willing to give it. That is the first finding. Now the second. 16th of February 1992, 8.5 months after Coagh. Sunday night, County Tyrone again. The village of Coagh, roughly 7 miles south of Coagh. Around 9 in the evening, 4 masked and armed men hijack a Ford cargo tipper lorry in Coagh. They tell the owner not to report it for 2 hours. An improvised metal mount is welded to the tailgate. A Soviet-made DSHK 12.7mm heavy machine gun, a weapon designed to tear through armoured vehicles, is bolted onto it. The unit also carries 3 Romanian AKM assault rifles. One of the 4 men is Kevin Barry O'Donnell, 21. The others will die with him before the night is out. The attack they are about to carry out wasn't a mortar strike, despite how some accounts describe it. It was a heavy machine gun assault. The distinction matters because of what it tells you about the weapon's silhouette, its rate of fire, and the weight of the danger the security forces were confronting. At roughly 10:30 p.m, the lorry pulls up outside Coagh RUC station. Approximately 60 rounds of 12.7mm armour-piercing tracer are pumped into the fortified base. No police officer or soldier is injured. The unit drives off, up Anaga Hill, past the home of Tony Doris, killed at Coagh the previous June, where the gunmen fire into the air and shout, "Up the RA! That's for Tony Doris!" Witnesses report Irish tricolours flying from the back of the lorry. The attack was expected. RUC Special Branch had received intelligence that the East Tyrone IRA planned to hit Coagh RUC station using a DSHK mounted on a stolen lorry, and that the active service unit would gather at the car park of St Patrick's Church in Clonoe, 2 miles away, to prepare, and return afterwards to dismantle the weapon and escape. 12 soldiers of a specialist military unit, widely identified as the SAS, were already in position behind a hedgerow on the southern boundary of the church car park when the evening began. Their orders were to attempt an arrest. The lorry arrives at St Patrick's car park shortly before 11 p.m. Getaway cars are waiting. The IRA men begin the process of abandoning the vehicle and dismounting the heavy machine gun. None of them is aiming a weapon at the hedgerow. None of them, the inquest will later establish, fires a single shot in the car park. The soldiers open fire without warning. The initial volley is suppressive fire from behind the hedge. Then the 12 operators advance in pairs into the car park, using fire and manoeuvre. More than 500 rounds are fired. 514 spent cartridge cases are recovered at the scene, and the total may have reached 570. Kevin Barry O'Donnell is first shot in the back while trying to run, then shot again in the face as he lies incapacitated on the ground. Sean O'Farrell, 22, is shot in the back while running, then in the face while incapacitated. Peter Clancy, 21, is shot while trying to flee, then repeatedly while crouching or kneeling. Patrick Vincent, 20, is shot while seated in the lorry cab, then shot again while lying wounded across the seat. Aidan McKeever, present in the car park, is struck by 15 bullets and seriously wounded. At least 2 other members of the unit escape. The soldiers' initial accounts claimed an exchange of gunfire, that they had come under fire and responded. The inquest demolished that claim. Ballistic evidence showed none of the IRA weapons were fired in the car park. The spent Soviet 7.62mm cases found at the scene, 30 outside the RUC station, 6 along the escape road, 15 in the lorry bed, were all from the attack on the barracks, not from any gun battle at the church. The state agencies, Mr. Justice Humphreys later found, had perpetuated falsehoods about the incident. The word ambush appeared in RUC and MOD documents written after the event. As the coroner observed, it's difficult to understand why experienced police and military officers would use that language, if, as the state insisted, ambushes weren't a tactic used in Northern Ireland. The inquest into the Clonoe deaths opened in 2023. On the 6th of February 2025, Mr. Justice Michael Humphreys delivered his findings. This time, the same judge who found Coagh justified reached the opposite conclusion. At the outset of his decision, Humphreys identified 3 questions that arise whenever state actors use lethal force. First, did the soldiers who opened fire have an honest and genuine belief that lethal force was necessary? Second, was the force used reasonable for self-defense or the defense of others, having regard to the circumstances they believed existed at the time? Third, was the military operation planned and controlled so as to minimize the need for lethal force to the greatest extent possible? The answer to the first question at Clonoe was no. The soldiers, the coroner found, didn't have an honest and genuinely held belief that the use of force was necessary to defend themselves or others. The answer to the second followed. The use of force was, in the circumstances they believed them to be, not reasonable. In each case, he found, the use of lethal force wasn't justified. The answer to the third question was the structural core of the finding. The operation wasn't planned and controlled in such a way as to minimize to the greatest extent possible the need for recourse to lethal force. Humphreys explained why. The experienced soldiers lying in wait knew the IRA men would need to dismount the heavy machine gun from the lorry and secure it before it could be used against them. Waiting for that disassembly to begin would have significantly reduced the risk of an exchange of fire and substantially improved the unit's ability to arrest the suspects. Instead, the soldiers chose not to wait for this outcome, but to stand up and open fire. He added a pointed observation about intent. Only one of the 12 soldiers mentioned the possibility of making arrests in the course of police interviews. None of them contemplated effecting an arrest at any stage, including when the deceased were lying incapacitated on the ground or slumped across the seat in the cab of the lorry. No warning was given. No challenge was issued. No attempt was made to take any of the wounded men into custody. The finding wasn't a criminal conviction. An inquest does not name individual soldiers as guilty of murder. It determines how, when and where the deceased came by their deaths, and, under Article 2 of the European Convention, in what circumstances. But on the 20th of February 2025, Humphreys announced he would refer the case to the Director of Public Prosecutions for Northern Ireland, Stephen Heron, for consideration of potential criminal proceedings. As of the latest available records, no convictions have followed. In March 2025, the UK government confirmed it would mount a judicial review challenge to the Clonoe findings, arguing the coroner misapplied Article 2. That challenge was still pending in mid-2026. The reactions split along predictable lines. Unionist politicians called the finding ludicrous, perverse, and one that beggars belief. Former Veterans Minister Johnny Mercer described it as absurd. Sinn Féin's Cathal Mallahan said it confirmed that these 4 men were executed by the SAS without justification. Now the comparison, because this is where the apparent contradiction dissolves. Start with the proceedings. Coagh produced 2 formal outcomes. The first was an inquest finding in April 2024. Force justified. The second was a Court of Appeal ruling in April 2026. The coroner was legally entitled to reach that conclusion. But judicial review is a narrow mechanism. It does not ask whether the coroner was right on the facts. It asks whether he applied the correct law and made a rational decision. The Court of Appeal could uphold a finding it might not have made itself, and the boundaries of that review are strictly legal. Clonoe produced 1 formal outcome, an inquest finding in February 2025. It hasn't yet been through appellate review. The government's challenge is pending. That asymmetry matters. One side of this comparison has been tested by an appeal court, the other hasn't. Then there is the coincidence that makes the comparison uncomfortable for both partisan readings. The same coroner decided both. Mr. Justice Humphreys wasn't a state apologist in one case and a Republican sympathiser in the other. He applied the same legal framework, Article 2 ECHR and the common law of self-defence, which asks whether a soldier honestly believed lethal force was necessary and whether the force used was reasonable in the circumstances as he believed them to be. He answered those questions differently because the evidence pointed in different directions. At Coagh, the unit was in the act of carrying out an assassination. An armed man had exited the car and pointed a rifle at a soldier. The threat was imminent and specific. The coroner accepted that the soldiers honestly believed lethal force was necessary to prevent loss of life. The unarmed driver was part of a collective unit moving to murder. The Court of Appeal endorsed the view that treating the car's occupants as a group of terrorists who posed a collective threat was sustainable in law. At Clonoe, the unit was in retreat. The attack on the police station was over. The men were dismounting a machine gun, not sighting one on the soldiers. No warning was given. No shot was returned. Men were shot in the back while running away, and again in the face while incapacitated on the ground. Nobody attempted an arrest. Under those facts, the coroner found, an honest belief in the necessity of lethal force wasn't available. IRA membership alone does not make lethal force lawful. Being unarmed alone does not make it unlawful. Those are relevant facts, but the lawfulness of force turns on the circumstances at the moment it's used. The immediacy of the threat, the conduct of the target, the alternatives available to the state. At Coagh, the court found the driver belonged to an imminent lethal threat. At Clonoe, the coroner found the threat didn't justify shooting men who were fleeing or disabled, particularly when waiting would have allowed an arrest. There is one more layer the record forces into view: the integrity of the evidence each proceeding relied on. At Coagh, the single most probative piece of evidence, the surveillance video, was deliberately destroyed. The coroner said its survival would have made his task on many issues straightforward. It was destroyed to protect soldiers' identities, and the judge described the attitude behind that decision as a clear and unequivocal willingness to subvert the rule of law. The original RUC investigation was, in his words, woefully inadequate, and the decision not to prosecute rested on untested and unchallenged accounts. At Clonoe, the state's initial narrative, an exchange of gunfire, was demonstrably false, and the coroner found the state agencies had perpetuated falsehoods about the incident. The RUC accepted the soldiers' accounts without challenge, which, in his words, ensured there would be no actual accountability. The word ambush in official documents contradicted the official line about how the security forces operated. So neither finding rests on a complete, unvarnished record. The Coagh conclusion that force was justified survives on the evidence that remained after the video was burned. The Clonoe conclusion that force was unjustified rests on evidence the state spent 3 decades resisting. The legal system can only work with what reaches it. That is why the 2 partisan responses to this story both miss the mark. The first response, the well-done 22 SAS position, reads Coagh as blanket validation of Special Forces operations. It can't absorb the Clonoe findings. The same coroner found the 1992 force unjustified on evidence of no warning, no returned fire, shots to the back and face, and no attempt to arrest. And it can't absorb the Coagh inquest's own criticisms. The planning failure, the destroyed video, the woefully inadequate investigation. Coagh was a lawful engagement conducted inside a flawed operation. That distinction is the entire game. The second response, murder basically, reads Clonoe as proof of murder and of a statewide shoot-to-kill policy. It runs ahead of the law. The inquest found the force unjustified and unreasonable, and some reporting described an unambiguous finding of unlawful killing, though that exact phrase does not appear in the official summary. But an inquest does not enter convictions. It does not name individual soldiers as murderers. It establishes facts and, where appropriate, refers the case to prosecutors. The coroner made that referral in February 2025. Nothing in the finding converts itself into a criminal conviction, and no conviction has yet followed. Murder, basically, is a political judgment, not a legal one. This is the core of the matter. Opposite accurately describes the outcomes of these 2 proceedings. It does not describe a contradiction in law, and it does not license a sweeping verdict on the SAS, the state, or the IRA. It describes 2 different answers to 2 different factual questions, produced under 2 different procedural frameworks. The conclusions track the evidence. The evidence tracks the operations. False equivalence, forcing both ambushes into one moral or legal frame, is the obstacle to understanding either. 7 men died in these 2 ambushes: Tony Dorris, Lawrence McNally, and Michael Ryan at Coagh, Kevin Barry O'Donnell, Patrick Vincent, Peter Clancy, and Sean O'Farrell at Clonoe. All were IRA members on active service. One man, Aidan McKeever, was seriously wounded. The conflict that surrounded them killed more than 3,500 people. Too many deaths on both sides. No court finding changes that arithmetic. The full inquest judgments are public documents with citations a viewer can look up. NI Coroner 22 for Coagh, NI Coroner 1 for Clonoe. The Court of Appeal's ruling in the Nugent case is summarised on the Northern Ireland Judiciary website. But what is public isn't the whole record. The intelligence reports, operational orders, full ballistic analyses, and the testimony of every soldier involved haven't been published in full. At Coagh, the most important exhibit no longer exists. At Clonoe, the original investigation preserved the soldiers' accounts without testing them. The public record is a partial record, and both findings rest on evidence the public has never fully seen. Which specific difference should a viewer check against the complete records? The driver's conduct at Coagh, Doris's movements and weapon status in the seconds before Soldier B fired. The operational planning findings in the Clonoe inquest. The decision to open fire rather than wait for the machine gun to be dismounted. Or the legal standards themselves. What judicial review will and won't correct, and what an Article 2 inquest exists to establish. Any of those, checked against the primary documents, will show the same thing the judgments show: that the lawfulness of lethal force is decided circumstance by circumstance, not side by side.